In this video I want to talk about regulations, a topic which many might consider to be the least sexy part of legal study. Certainly it doesn't have the drama of the courtroom or the profundity of presentation of legislation before Parliament, but increasingly we live in a society that is governed by regulation. That is, rules that are derived from legislation, the power is conferred by legislation, but the rules are created by other bodies and administered by other bodies. So regulations are legal instruments, but they are the creatures of statutes, and the originating statutes confer power onto someone else to create regulations. So the law says the dog catcher will go out and catch stray dogs, and then gives the power to the dog catcher to make up regulations in the way in which they go about that business. It's a principle of governance that we've used for a very, very long time in our culture, and it's something which is accelerating because as society becomes more complicated and more interconnected and works more across boundaries, these rules have become more complicated, and as rule sets intersect with each other, it becomes very, very complicated. And today, a new piece of legislation has to create, in many jurisdictions, is required to have a regulatory impact statement be presented and prepared before it gets passed in order to understand what is going to happen to this complicated network of machinery that already exists. Is this going to work with everyone, or is this going to throw a spanner in the works? So it's important to know the relationship between the originating legislation and regulations, and that's going to become up again. And there is an old-fashioned term that we used to use. We used to call regulations delegated legislation, which sums up what it does, but of course is needlessly confusing. So we do tend to call them regulations, although sometimes we call them bylaws or ordinances or by other terms. The reason we do this, of course, is the time and complexity required to put an act through Parliament, and the resources that requires. And sometimes you need regular updates. And this is where regulations come into play because they can be updated more simply and more quickly. And what they require is that the regulations be published in the Government Gazette. Now, that's an interesting topic in itself because I don't know about you, but I don't sort of, on my daily trawl through social media, pop by the Government Gazette to see what's going on. And I think it's one of those areas in which the era of joined up digital government needs to catch up, that we need to have a better idea of how this information is shared, how it gets out to people, how people understand and interact with regulations. So this is a really interesting frontier in the law, and one I think that needs some pretty close attention because the rate at which the volume of regulation is increasing is quite extreme. Okay, so regulations are a function of the executive arm of government. If you remember your separation of powers, it's not part of the legislature hands the power over to that regulatory, to the authority of the executive. And it may be to the minister themselves. It may be the minister is empowered to make decisions and to create rules under the law, or it may be to someone, to the dog catcher, who eventually answers to the minister at the top of the tree, but is not someone who is very highly placed. So regulations can exist at different levels and be delegated to different people. Of course, once these regulations are created and they're reported in the Government Gazette, there's always that question of how do you find it? And again, fortunately, in this day and age, we quite often have regulations and codes of conduct and regulatory codes, all those sorts of things, on websites. So they're at least out there somewhere, but finding them can often be difficult. And this is where the role of the researcher becomes very, very important. A researcher sometimes needs tenacity to be able to follow these things down, to find the most up-to-date version of the regulations and to understand what they actually mean. So one of what I think is the most successful examples of regulation is the building code, that all jurisdictions have a building code. And this often involves thousands and thousands of pages of specifications, of measurements, of values, things that are perfectly arcane to the ordinary person, but absolutely central to creating a safe environment in which we live. So let's have a look at one of these instruments right now. Now, this is the Guide to Standards and Tolerances 2015, and this has the interesting distinction of not even being a formal part of the building code. This is something which is a set of additional regulatory standards that people can agree to as part of the contracting process, which is nevertheless indexed with and contained within the building code. And I think it's a fantastic example of how complicated and interconnected all these provisions are. It's also got some pretty nice graphic design on it, and one thing you'll tend to find after spending a bit of time trawling through regulations is that they tend to be not so easy on the eye to read, and they tend to be in small and crabbed text. So we can have a quick flick through some of this stuff, and we'll see again the lovely graphic design, but the different topics that are covered, including masonry facing, blending and matching of masonry work, voids and holes in mortar, cracked masonry units, horizontal alignment of bed joints, roof tiles, roof pointings, overhanging of roof tiles. Now this stuff is incredibly important. It's something that's a great mystery to myself, as I suppose areas of law would be to someone who worked in the building world, perhaps. But I think it's fascinating when we look at the level of detail that's included in drawings, in specifications, in measurements, in instructions on how to look at objects, in sections and subsections and clauses and explanatory notes and memoranda and references to guides and description of the limits of cracking and how much of a crack, the width of the crack can be, the amount of subsidence that can occur, and we could go on further and further and further through this stuff, and it would be a deep dive into the building code if we were to spend a lot of time with it. However, that's not to say that that's not something that lawyers aren't required to do from time to time. The complexity of the society in which we live requires this sort of attention to detail in lots of different areas of regulation. And that means for lawyers quite often the development of an interdisciplinary practice and areas of specialisation, where if you're a building lawyer, not only do you know your way around the law, but you also know your way around the regulations, and I guess you know one end of a chisel from another in order to be able to apply those things. And this is where we really, I think, get to understand where legal specialisation works. It's not because you studied family law as an undergraduate subject and therefore become a specialist in family law. It's not really how it works. How it works is you develop a specialised set of interdisciplinary knowledges around something in particular, whether it be horse racing or alcohol vending or something else that other lawyers don't know about, and that's where you develop these kinds of special skills. So this complexity also means that there's an ongoing balancing act between the needs of complex governance in society on the one hand and freedom in the other. And you'll often hear people complain about the amount of regulation. And the situation where food preparation laws require people to be qualified in TAFE qualifications in relation to hand washing, for instance, is something people often find quite ridiculous. Do I need a certificate to tell me how to wash my hands? And I think the fact that we have that probably means some people do need a certificate to show they know how to wash their hands, because there's obviously been situations where that's been a problem in the past. But it also shows, I think, those complex things that come out of a participatory democracy and the amount of power that we've delegated away from those representatives to a lot of bodies that make those decisions and make up those schemes that actually govern us in everyday life. And while that may be concerning, we do have a remedy there, and that's administrative law. And the whole purpose of administrative law is as a check and balance on the exercise of that power, and to provide oversight of not only the creation of those rules, but also the application of those rules along the way. So there are certain tools within the administrative laws tool set. Now, you may have studied admin law before and you'll be perfectly familiar with this. If you haven't, here's a very quick rundown. The first set of tools is what's traditionally known as ultra vires, Today it's often known as excessive power. I like the Latin, but that's a personal taste thing, I think. And what ultra vires is concerned with is the authenticity of power being exercised under the original grant of power. So if the dog catcher is granted the power to go and catch dogs and starts catching cats and weasels and ferrets and people as well, the dog catcher has gone outside the power that was delegated originally under the original legislation. And the same happens where the administrator creates rules. So they create their own regulations, the dog catching regulations, and they say, I can pick up stray children as well as part of what I do. And for many people, their own rules become what they live by, regardless of whether those rules are authentic. So when someone's children are picked up by the dog catcher, I know this is a ridiculous example, the dog catcher produces their regulations and says, hey, it says under section 74, subsection 2, subsection 3, part 1, 2, in the 5th schedule that I'm permitted to pick up children. And what administrative law says is, well, you've got to go back to the original grant of power under the Act, and it says you can't do that. And it doesn't matter how many rules, regulations, and subsections you've created that say that you can. So that's the first check and balance. The first tool in the admin law toolkit is that strict reference back from the originating act to the regulations and to the decisions made under the regulations to say, well, do you actually have the power to do that, or do you only think you do? The second set of useful tools that admin law provides us is the idea of procedural fairness, and this is the idea that all grants of power basically fall under the same framework, that it's almost an unwritten part of this delegation of power that you should be following fair process when you do it. And we don't have to, every time we delegate power, say, and by the way, you have to follow this, you have to follow that, and you have to follow that. And the rules of procedural fairness provide a framework for good governance, for good solid regulation. So they suggest things like, or they mandate things like, everyone has to be given the right to be heard. You can't affect their rights without giving them an opportunity to present their side of the debate. You have to be free of bias in your decision making. You have to have good evidence for your decision making, and there are a series of rules, and we have these codified in law, and we have precedents obviously around them at all, and this is why you spend a whole period of time studying admin law as well. But I think it's important to recognise that admin law isn't just some abstract area of law, that it's actually centrally concerned with the modern state and putting the brakes on the tendency of the modern state to get out of control. And for administrators, whether they be the dog catcher or whether they be the minister in charge of a department, are still governed by the law. And they still have to go back to the original law in which they are given power, and they have to exercise that power in a way that's fair and decent. And it's amazing how often bureaucrats lose sight of that and get very much preoccupied with their own regulations, their own instruments, and their own little world which tells them what they can do. But of course these are rules they've created for themselves, so of course they tell them they can do anything they like. So admin law is really about protecting individuals, organisations from that kind of power. Alright, let's step back to the core topic of discussion here today, which was the importance of regulations. As I said at the outset, many people don't consider this to be the sexiest area of law. In legal education, we basically only really touch on it in administrative law, and I know some people have bad experiences of admin law. I'm not sure why. I think it's an very interesting subject myself, but everyone has the things they like. But I think that provides a disproportionate understanding of how important this stuff is, both to real life out there in the real world and also to legal practice. That even though you spend the majority of your law course looking at what happened before the High Court, most of us are not going to get anywhere near the High Court. And most of us are much more likely to be in that field, embedded in that field of regulation, where we do need to understand what the telecommunications regulations are in my particular background. Or you might be a building law specialist and you need to know everything about the building code and how that applies. And it does mean that we have to have that broader idea of expertise and that broader idea of research and understanding outside of the law. But the good thing about it is you actually, when you do find something and you do manage to master this field, you do feel like a wizard who's found the Philosopher's Stone. It's certainly an area that if you master it, it's a really good feeling, and you really feel as though you've achieved something.